Is there any real major difference between an individual or a couple buying, like in terms of, the ownership structure, tenants in common, joint with rights of survivorship? What do you got for me there? Like, is it pretty straightforward, or is it a completely different ball game when a married couple or common law spouses buy a property?
Sure. So I guess the first point is, of course, if you're an individual buyer, you're the only person who needs to get approved. It's your financials. Obviously, if there's a cash deal, there's no approval of that. But if it's a cash individual buyer, it's just you. It's your credit. It's your financials. It's your background check. You're the only person who's going to be considered and interviewed and approved. You add another person to the mix. Now you have another person that needs to get approved. That they could potentially, if they have poor credit, that could potentially be a negative. That could be a drawback. They're still going to be a co-owner. They're going to be presumably on that contract. They're going to be on title to the property. They're going to need to get approved. They're going to need to submit an application. So you have two people in the mix that things could go wrong for that person. Even if one person has great credit, the other person may not. So something to be aware of there. With respect to how you own the property, so there's ways that you hold title if there's more than one person. Two common ways in Florida for individuals, there's going to be joint tenants with right of survivorship. Pretty much just means if you and another person buy a property with right of survivorship, one of you passes away, the surviving person gets 100% ownership. The other structure is called tenants in common. So you and the other person own it as tenants in common. One of you passes away. The other surviving person does not automatically get 100% ownership. Your 50% interest would pass to your heirs. So that's the other way to do it. If you're a married couple, the default would be survivorship, right of survivorship.
Right.
Automatically, even if the other spouse isn't even on title, they have to sign off on the sale because it's a spousal state, right? How does that work?
Well, you're talking about on a sale. So I'm referencing on a
on a buy. Yeah.
Right. So on a purchase too, I guess
if
you buy it and you have a spouse, you could buy it alone, but the spouse automatically inherits it or owns it.
Joint with rights of survivorship, by definition,
but if you don't put them on
in
title,
any common law jurisdiction, is going to be you die, whomever it is that is joint automatically gets
whether
it.
they're on. But what if they're not on the title, right? So I go out and I buy a condo or a house, and I just go sign the papers. I buy it cash, and it doesn't know, right?
So then it would go to your estate, I'm assuming, and your will would dictate where the property goes.
That's right. And then there's obviously nuances that come into play. This gets tricky and lawsuits happen, and we have to perhaps go down the probate road depending on if the property is going to be homestead or not, because in Florida, homestead gives rights to surviving spouses, but if you're alone on the deed, sometimes there's ambiguity of whether or not you properly claimed homestead. I'm actually dealing with that right now on a closed transaction from last year. But there's some complexities when you don't have both people on that title. So the general rule of thumb is if you're married, you want to put both people on that title just to avoid any issues down the road. The surviving spouse for homestead is protected, but don't leave that up to the court. Don't leave that up to interpretation.
It's expensive. Yeah,
it's expensive.
That's
it's timely.
Yeah.
So if it's not going to be if it's not going to be an investment property, which we can get into that in a second. Investment property should always be held in the name of an LLC, and we can go into that. I'll pass it back to you to ask any questions. That definitely for primary residences have to be, of course, in an individual name. You can't have a primary residence in an LLC because a corporation or a company can't have a homestead.
How about a trust?
A trust is a little bit of a different animal. So you can have a homestead in the name of a trust. Okay. However, a trust does not offer any liability protection.
Correct. Okay.
And that would be a living trust of some sort.
That's right.
That in the event of you passing helps the probate process or passing that asset down through
with multiple beneficiaries.
That's right. So a trust is an asset protection vehicle. So a trust is not a liability protection tool. It's an estate planning tool. It's an asset protection tool. So when you have a trust, that's a way for you to avoid probate. So for instance, I have a revocable living trust. I own my home in my trust. If I pass away, I don't actually own my property. My trust owns my property. Whoever I've designated as my beneficiaries in my trust would ultimately become the beneficiaries of the home. So that's a way to avoid the probate court. But if you passed away without a trust and you didn't have your property titled in a trust, even if you have a will, and I'd like to point this out, I get this question a lot. If you have a will and you leave your property to your son, your daughter, you still have to go through the probate court, because the court has to validate that will, make sure that it's proper, there's no challenges to it, and then the court will determine that, okay, it is a proper, valid will, and property can be devised to that beneficiary. But if you're not going to own it in an LLC because it's not an investment property, certainly a trust is a smart way to avoid the inevitable death that we're all going to face at one point.
Right.